So without any further ado, I want to introduce our panelists for today. First of all, I'm Marice Ashe. You may know me. I was the founder and CEO of Change Lab Solutions, did that for many years, and now in retirement, I lecture at Berkeley Law. And our main presenters today are Micah Berman and Scott Burris. You know them as the co-authors of the new public health law. We'll reference that a couple of times today. Micah is a professor, has a joint appointment at Ohio State in both public health and the law school, did his training at Stanford. Scott is professor of law at Temple and also the director of the Yale, of the Center for Public Health Law Research. So next, Bethany. And behind the scenes, we have Bethany Saxon. Bethany is kind of our coordinator of all of this. So welcome and introductions. Here we are. We will be going through a lot of doctrine today, very quickly and with a perspective. We are bringing a perspective to this work that the judicial activism is taking public health on. We're at the tip of the spear. Public health is under siege, and we're going to talk about how that's happening over and over again. Again, leading up to what do we do about this? We are a public health law community. How are we going to address what's being thrown at us? So we'll go through, Micah will start and can see the list of what we're going to be covering. Scott will follow. Then we'll talk about practice and strategy skills for students. And this is where we'd really like your crowdsourcing for more and better ideas. We've got some starter ideas. And then we'll have open discussion. And again, all of this will happen through the chat function. So with no further ado, Micah, I'm going to pass this to you and launch us.
Thanks, Marice, and thanks everyone for joining today. From a teaching perspective, the most important thing that I can tell you is that we update the teaching materials for our book every year. So this is our book, if you're not familiar with it, The New Public Health Law. It is co-authored with Scott Burris, who's here, and then also Matthew Penn and Tara Ramanathan Holiday, and the four of us get together every summer and try to incorporate new cases, new scholarship, and there is a lot of it. So if you're going to teach this year, if you're interested in teaching public health law, please go to our website, thenewpublichealthlaw.org. You can click on the contact link, which is there, and just tell us who you are and where you're teaching, and I will send you the password to unlock the teaching materials. So today, as Mara said, we're going to go through a lot very quickly, but there's a lot more material in the teaching materials, the teaching manuals, lots of links, lots of discussion, and so hopefully it'll be a helpful resource for you. Just a quick teaching note, Scott and I both teach primarily law students when we're teaching public health law, so obviously you have to teach it a little bit different. I know a lot of people on the Zoom are teaching to public health students or medical students or others. What we very intentionally tried to do is make both the book and the teaching materials flexible so that it will work for law students, for public health students, for medical students, for any combination thereof. And so I'm just going to say that for now. We can have more discussion about that later on if people want to. All right, next slide. For people who have used the book, you know that our outline is based on this 5 essential public health services framework. And that's something that both Scott and Marice were instrumental in developing. And the book reflects our view and the view of this framework that understanding legal doctrine is important, but it's only one of the important things if you are trying to move public health and public health policy forward. And so a lot of the book focuses on other things, the skills that are needed to take public health evidence and turn it into effective policy change, and knowledge of law and lawyers are only one piece of that. But that piece, that the legal doctrine is the place where we've had the earthquake in the last few years, and there's been a lot that has been changing. So that's what we're going to talk about, but I think it's important to recognize that the broader framework around that is essentially unchanged. Certainly the politics of public health have also gotten more complicated, but the general framework we think remains, and learning all these other skills remains vitally important. A lot of what has changed on the doctrine side has not been good. We are not bringing you a lot of good news today, but change is a constant. And so, from the beginning, I think what we were trying to convey with this book is that law changes, the environment in which law is made changes, and it's part of the responsibility of students who are going out into the world and want to be a part of public health efforts to understand how things change, why things change, and understand that legal change happens in various directions over a long period of time. It doesn't happen by accident. It happens because people often, over generations are trying to push the law in a particular direction. And so we want our students to see themselves as understanding that process and going out into the world where they can then have the skills needed to engage in that process. So next slide just gives you the quick outline of section 3 of the book, which is where we have the core legal doctrinal content. I'm going to quickly try to cover the material covered in chapters 8 through 12 and talk about what's changed there. And then Scott will talk about 13 and 14. So next slide, we're going to jump in with talking about state and local public health authority. And this is where the Supreme Court has so far been less of a player than in the other developments we're going to talk about. But that could change. And I think one theme here to think about in terms of teaching is that what we've seen happen in the last few years gives us increasingly stark examples of why public health authority matters, why these questions of authority are not just theoretical, but really matter for people's lives and their health. So next slide is, federal preemption. For example, the Supreme Court last term stepped back from ruling on the EMTALA case that came out of Idaho, but that case shows the very real stakes that are involved in these questions of authority and preemption, and it will probably come back in some form to the Supreme Court as soon as the election is over. And it's a reflection of sort of how bleak things are, that this is now the legal battleground. But that case was, in short, about whether EMTALA, which is the Emergency Medical Treatment and Active Labor Act, preempts state laws that criminalize abortion care provided by emergency room doctors in emergency situations. And kind of goes without saying, the answer to that question is really, really important to pregnant people, to the doctors who find themselves in that situation. It's important for the healthcare systems to understand that and figure out what happens in those situations. And in terms of people's lives, people obviously don't know whether they're going to have one of those emergencies in advance. So it really goes to the fundamental question of whether you can safely be pregnant in certain states. So that's just one example. On the flip side, there's an election coming up. There has been discussion from the Trump team, from Project 2025, about the Comstock Act, which is the Comstock Act of 1873, which has long been considered dead letter, but could be used to try to essentially prohibit abortion nationwide, certainly prohibit the mailing of abortion pills nationwide. And so this area is a really important one to watch. On state public health authority, there's a lot of changes between states, but as part of the COVID backlash in some states, there have been pretty substantial changes that limit the authority of governors, the authority of health departments to deal with the next public health emergency, whatever that happens to be. In some states, there has been kind of shockingly aggressive preemption at the state level, kind of sucking away large swaths of authority from local governments. I guess minor point of good news is that for teaching, it's a good opportunity to introduce students to legal epidemiology. The Center for Public Health Law Research has data sets on legal changes regarding public health authority. They have legal data sets on preemption. It's a good place to have students jump in and try to get a sense of what is happening in their state and how it compares to what's happening in other states. The next slide has some resources. For time purposes, I'm not going to go through all of them, but just wanted to really flag the one on the top right, the article by Sabrina Adler and others, including Scott, which talks about the changes in public health authority and then links them to actual consequences that are already happening. One of the examples used is the example from here in Columbus, Ohio, where we had a measles outbreak in a daycare center, and the health commissioner was told by her lawyers that because of changes in the law, she did not have the authority to order that daycare center to be shut down. And because of that, we ended up with a larger measles outbreak than would otherwise have occurred. So as I said, I won't go through these resources, but I think it's important, and this is clear in the materials, to talk not about the changes that are happening, but why they are happening, who is pushing for them, who is pushing back against them. And I think preemption gives one example where you can have that conversation in a very clear and concrete way. All right, going to move ahead to due process and equal protection. Now getting to what the Supreme Court has been at the center of. Again, I teach law students, so they get some of the doctrinal content in their first year or maybe early in their second year of law school when they take constitutional law. So I see my job as building on that and advancing that discussion to focus on the public health piece of it. What is the public health impact and what comes next for people who want to be involved in public health and working to advance public health policy? So next slide has some big picture points that apply to most of what Scott will cover as well, regarding both, how I think of these cases and then how I try to teach them. And these are pretty blunt, but I think these are important points to be clear about. So first one is that the Supreme Court is shifting towards tests that can produce the outcome that it wants, and that very explicitly do not take public health evidence into account. And I think it's just important to be honest about that with students, that this is what, at least in our view, is happening. And if you try to teach these cases as just kind of standard legal doctrine that makes sense and leads to predictable answers, the students are going to get really, really frustrated because these doctrines just don't work that way. Second, it is difficult just on a human level to teach cases that in some instances are just fundamentally cruel and that have doctrine that is inconsistently applied. I think these cases in many instances are disrespectful to just the lived experiences of women, of people of color, of LGBTQ plus individuals. And, it's really hard to teach cases like that. I mean, it's hard for me as someone who does not share those identities. I'm sure it is substantially harder for people who do. And in these cases, the equal protection cases, the due process cases, I think the court is just sort of being gaslighty in all sorts of different ways, sort of telling people they're having experiences that they're not, and telling people that they are, just applying neutral, obvious legal principles that lead to nothing but the result that they, or can lead to nothing but the result that they reached, when, going back to the first point, that is not what actually is happening. Third point is precedent doesn't mean what it used to. I'll talk about Dobbs in a second. Dobbs, I think, just broke the dam here. And if the court is willing to overturn a really settled precedent like Roe, which had already previously been reaffirmed quite explicitly by the Supreme Court, just because the court now thinks that that case was wrong, then that can happen with pretty much anything, and sort of all bets are off in terms of precedent, at least of the Supreme Court level, and that is rippling down now, I think, in some ways to the appeals courts. And then finally, back to the skills piece of it, I think we just need to be having this discussion about, if your goal is to advance public health, is Supreme Court litigation the way to do that? How do you maybe keep cases out of the Supreme Court that are otherwise heading there? And then what other types of approaches are needed, and what other types of skills are needed? And I just want to add a note before going on to the next slide, that just all of this is a lot in kind of every sense of the phrase. It is a lot to deal with emotionally. It is a lot for students to deal with emotionally. It is a lot of content, and so you have to make difficult choices about what you're going to teach. It's also, politically charged. It can be uncomfortable to teach these subjects. So, we don't have time to dive into all of that today, but I just wanted to flag that and sort of validate what I've been hearing from a lot of people about that, and we can jump into more of that in the Q&A when we get there. So just to go through due process equal protection doctrine real quickly, the big case on the due process side is Dobbs. I think it has to be read as the work of an activist Supreme Court. I try to refrain in my teaching from calling it a conservative Supreme Court, because cases like this are radical and destabilizing, not conservative. And then on the doctrinal piece, these are the key points that I focus on, and they're all linked to each other. The court has now put everyone on notice, despite putting in some caveats and saying that it wasn't what they were doing, that not only is this court not going to expand the list of fundamental rights protected by the due process clause, but they're now willing to take ones that have been previously recognized as fundamental rights off the board, which is something that has just never happened before in its history. And then when you combine that with seriously lowering the bar on stare decisis and introducing new tests that focus on history and tradition, you are left with pretty much all of due process up for grabs, and not a lot of clarity about where it's going to go in the future. And I think the one clear way to see this is that if you look at Dobbs and then you go back and read Obergefell, which was from only 7 years before that, where the Supreme Court recognized a right under the due process clause to same-sex marriage, it is really hard to read those cases and square them with each other. I think it's actually impossible to read those two cases and square them with each other. They are clearly the work of different courts. And so, what that means for the future is pretty unclear. And, it has huge impacts for people trying to order their lives. I already talked about EMTALA, but also, maternal care more generally, not just emergency care. If people are worried that their day-to-day work is going to be criminalized, they're going to go provide care in other states. We've already seen that happening, and the result of that is to just deepen inequities around infant mortality, around maternal care that already pre-existed the Dobbs decision, and that are quite likely, I think, to get worse. So, what do we do in terms of talking to students about lawyering, about public health practice? I think these are some of the questions. Do you argue on the Supreme Court's terms? Do you tell students that they need to be historians now and try to make their own different historical arguments? Do they need to think about reframing due process arguments to characterize some of these fundamental rights at a broader level? Is that going to have an impact? Or do they need to think about, as I said, keeping some of these cases out of the Supreme Court and finding other avenues, whether through at the state level, at state courts, through changing state constitutions, other types of legal arguments to move some of these public health goals forward. And I think,
Micah, as we proceed, I just want to pay attention to time and to let Bethany know that I've gotten word that the chat function isn't working. So if you could double check that.
okay, yes, I will try to get to the end quickly. So, whatever students are going to do, I think giving them the skills to track the public health impact and track the research and be involved in that research if they want to be, of these cases, and track the the legal and policy developments of efforts by some to push beyond Dobbs as well, I think is really important. So moving on to equal protection, the key case here, let me give 1 second for Bethany to move the slide. There we go. Key case here, the Students for Fair Admissions from last year, from 2023, Justice Sotomayor in the dissent, in her dissent, says that it turns the 14th Amendment's guarantee of equal protection on its head. And now we're left with an amendment designed to promote equal protection that now can't be used, according to the Supreme Court, at least in some contexts, to identify where there is still inequality, at least based on race, and to try to correct it. I mean, that's certainly the case now with college admissions, but there's a very active legal movement to try to expand that, quote unquote, colorblind approach into pretty much every area of law. And again, this has real impacts. If you can't take health equities that are a result of pervasive racial discrimination, if you can't take race into account when you're trying to address them, it makes it really hard to address them. And there are groups out there like Do No Harm, which is engaged in just extensive litigation against every program that it can find that uses race as part of what it's doing. Just gave some examples in these different headlines here. And again, this is something students can be involved in tracking. And again, it makes it difficult to think about lawyering, how to respond to that in the legal way. Again, do you sort of take the Supreme Court's framing as a given and try to argue from within it? Or do you think about options for changing that? And if so, how? And then how do you counsel clients? If you're working with the health department, what do you tell them to do? And I think a real issue here is kind of pre-compliance. Do you take a more risk-averse approach and get rid of programs or water down programs that are focused on health equity now in order to reduce your risk of litigation? It might, from a kind of traditional legal counseling perspective, that might make sense, but then your health departments are stepping back from their commitment to health equity, which is obviously really problematic. And then final slide for me is, this upcoming Supreme Court, we have United States versus Geretti, which is a challenge to the ban on gender affirming care for minors coming out of Tennessee. It raises both due process and equal protection issues, but the Supreme Court, at least for now, is only taking up the equal protection question. And in Bostock, just a few years ago, the Supreme Court held that discrimination on the basis of sexual orientation or gender identity is sex discrimination for purposes of Title VII. I think logically that would also apply to the Equal Protection Amendment, but there's an argument on the other side that no, Bostock was a bad statute. This is about the Constitution, so we need to look at history and tradition, which is obviously going to push the result in a different direction. The Bostock majority was actually written by Justice Gorsuch, joined by John Roberts. The plaintiffs in these cases need both of those votes if they're going to win. And so, I would say that makes me very nervous. Human and public health impact here, I think, again, are very direct. I think bans on gender affirming care are, I think, certainly just disrespect the humanity of trans people and probably very likely kill people. And so, we need more legal epi work on that, and we need to be tracking that over time. I think there's lots of, evidence questions here. This whole movement is based on really shoddy evidence. And it's really, again, hard to teach these cases. I've had trans students in my class over the last several years, and it's just really hard to teach these cases where courts are often talking about trans people in disrespectful ways and just invalidating their own experiences. So I think it's kind of the same lawyering and public health practice questions here about, what do we do both at the Supreme Court and beyond the Supreme Court to try to flip the Equal Protection Clause back onto its feet. So I will stop there and turn it over to Scott to talk about the rest.
Thanks, Micah. I want to remind everybody the chat is working, so please put in ideas, thoughts, things to talk about in our discussion section right in there, and Bethany and Marice will be organizing them. So I'll just pick up where Mike left off. Broadly speaking, we're in this fix of figuring out how to teach law to people when we have some grave doubts about what's going on with the law. There's maybe a variation of Michelle Obama's line about going high when they go low. We still have to take this seriously, I think, or at least project to them that there's a point to taking the law seriously, that the rule of law means something, and that we collectively have a stewardship role as people working in the system. Next slide, please. Still, if I imagine, maybe having a beer with Justice Kavanaugh, I get a sense of what they think they'd say to me, and I try and convey that to my students. I think we see a long-term project, and we'll talk more about the politics of that as well as the law, to make it possible for government to regulate for health and safety. This is an old thing in the First Amendment. For decades, we've watched as the Supreme Court gets more and more picky about anything that comes close to anything that looks like speech. We can still argue and occasionally win cases on the evidence, on the grounds that this is a good idea, that an appropriate way, not restrictive way, or least restrictive way, efficacious way to secure a public good. But the bar seems to get higher and higher. And frankly, we're no longer sure how long the court means to accept means and analysis anyway. Well, we'll talk about more in the Second Amendment. Now, in Breu, Supreme Court tells us, Justice Kavanaugh will tell us that our new rule is the framers made gun policy for all time, and there's really nothing left to add. You think we blinked in Rahimi? Well, maybe. I'll say more on that in a second. Next slide, please. And then we get to ad law. We now have been given a rule in which every potential plaintiff has their own personal statute of limitations to challenge regulations, no matter how long they've been on the books. And if you do get past that, friends, we have the major questions doctrine. So there's going to be a real question as to whether the rule that's been made could have been made, was authorized. And remember, as far as we can tell, and as far as the Supreme Court is telling us, a major question is any question that somebody's willing to sue about. So sui generis, pretty much by definition, if there's a case, it's a major question. Loper Bright, our big case from this term, on the one hand, maybe it's not such a big change. Not clear how Chevron, actually has made difference. But we're now being told no deference on the interpretation of law. And frankly, although we still have, as I'll say more about Skidmore, the idea that agencies do have expertise that courts should respect, we also saw Justice Thomas this term set his historical expertise aside and demonstrate how much he understands about gun technology, in which he decided in Guardians that a bump stock does not an automatic weapon make. And as the court has also told us now, that if you do get through all these hurdles and you're able to enforce a regulation against somebody who's violated it, forget about monetary fines unless you're prepared to take it in front of an Article III court. Next slide, please. So digging in a little bit, to me, some of the two big questions I think I face now in teaching regulation and thinking about the practice of regulation is whether evidence is going to matter. So we see this again and again, and it's not an easy question even with good doctrine. if we're asked to prove that a tobacco label works or some other warning works, is effective, is necessary, we're going to face the fact that proving that through research is actually pretty difficult, because the whole idea of comprehensive regulation is that it has many parts. And teasing out the individual impact of one part, if that's even a reasonable thing to try and do, given the idea that things might be complementary and mutually supportive, is pretty difficult. And that's especially difficult if it hasn't even been implemented yet. So all you're doing is something like a modeling exercise or a review of various kinds of policy candidate studies that test the mechanism of the law. It's very easy for a court to dismiss that as, pretty poor science. And that's even assuming that the justices have a real understanding of good versus bad science, which I don't think they do. I think actually, to the best you can say about the court's appreciation of scientific research on the health effects or on the effects of law, is that they share the general view that only an RCT is a gold standard, and anything else is never going to be good enough, which conveniently precludes much evidence coming in about the effect of an actual law. That's one problem. Second problem is whether, of course, as Mike has already suggested, we are actually dealing with serious legal analysis in which legal terms are supposed to have a meaning that we try together to make real and try together to make useful and predictable in future cases. So I think the version in our First Amendment stuff is particularly acute in Zauderer's in the case of Zauderer and compelled speech, where we have a sort of major questions like doctrine of whether or not the speech is controversial. So again, if someone's brought a lawsuit, well, it must be controversial. That seems to be what's coming out of the cases. Still, in a hopeful development, in a case this year in the Fifth Circuit looking at labels, there was an actual very serious lawyerly discussion of what Zauderer means and its specific prongs, among other things that rejected the claim that we saw in the DC Circuit in the last go round on labels, that if you have an emotional reaction to a picture, it can't be factual. And it also has this nice phrase that is useful, that the court should really graft upon its heart, that the speaker not liking the message doesn't make that message controversial. Next slide, please. Now we also have this whole emerging, I think of it as the emerging law of religious discrimination. Smith stands still. We still have this idea that laws that are neutral and generally applicable are, don't have to have exceptions for religion. But, we have RFRAs, which are really taking a lot of, giving us a lot of heat these days, not just the federal RFRA for federal law, but also state ones, where we are seeing that kind of high constitutional bar set for regulatory measures. But again, in a sort of, I don't know whether I should think of it as hopeful or ridiculous, but we have this interesting case out of Indiana in which the court held that it was a violation of the state RFRA to enforce restrictive abortion law against Jewish plaintiffs who had a religious faith reason for wanting to have access to abortion. We also have this whole area which we're seeing in workplace vaccination and still coming out of old COVID cases of anti-discrimination statutes of various kinds. And then the whole question of what employers or governments have to do in the way of making reasonable accommodation for people who object to some rule for religious reasons. Then, of course, we have, what's essentially the vaccine problem, which is you have a generally applicable law, but it has an exception for someone. And if there's an exception for someone, the apparent rule in, the suggested in tandem v. Newsom, for example, is that, well, if there's an exception that treats any comparable secular activity more favorably than a religious exercise, then that's a problem. Is this a kind of most favored nation treatment for religion? In the vaccine area, we have a long sense that you don't have to have a religious exemption from school vaccines, and if you have a health exemption, you don't have to have a religious exemption, and that was again upheld in the Second Circuit last year. But in Mississippi this year, we've seen a crack. So that's obviously something we have to watch. And then finally, we have this issue of enforcement actions that are explicitly referencing religious groups or activities, which was a feature of COVID. Now, I'm not sure the COVID cases generalize. There was a lot of poor drafting. I don't want any of my students ever to have a list of essential activities and then put religion off it. I don't think that's how we want to proceed in these kinds of situations. And there were some bad judgments as well, maybe arbitrary lines. But clearly going forward, we are going to have to be very careful about explicit or even sort of implicit religious distinctions, and making sure that there is really a solid reason for that, which may entail also some interrogation of our own values in a healthy way. Next slide, please. Now, of course, we got the gun thing. That never gets better. It was, I hate to say it, fun to see the court tripping over the Breu Test in Rahimi. They really could not deny Justice Thomas's pure and inane history and tradition test. But what they went out to instead is no better, really. It's just a sort of common law dodge. From now on, we're just going to be doing our traditional common law reasoning. And as Micah suggests, no doubt getting to the exact outcome they would get to anyway. They are not backing away from the rejection of evidence and means and reasoning. Next slide. On the other hand, again, litigants and courts are dealing with this. So I point to a case out of Rhode Island looking at their large capacity magazine ban and upholding it. This case is, what the kind of obvious step we need to take and get into our doctrine, right? So if the court is saying that if the framers made a decision about gun law, the kind of gun law we could have in 1783, that's fixed. We can say, wait a minute, it's okay if they made a decision in relation to a problem that existed back then, all right. But we can't say they settled an issue if the issue didn't exist back then. And so Ocean State Tactical spends a lot of time talking about how new mass shootings are and how new these guns are. And I think that's obviously a productive way that people will be going. Next slide, please. Now, when it comes to teaching and working with Loper, and I think this really applies to everything we've talked about, we can always focus on the doctrine, right? I mean, that's useful. It's important, particularly in the case of Loper, or talking about ad law. Skidmore remains good law. Bottom line is that we can make the same arguments about the expertise and the importance of understanding the guidance of agencies as we could before. It's also fair to see if the court has really, is the dog that caught the car. Clearly, the court, as Justice Kagan notes in her dissent, really is now holding itself up as pretty much a super legislature and super executive. It is a branch that everything must, with veto power over everything everybody else does. And that's problematic in and of itself in talking about separation of powers, but it's an easy job. Is the court really prepared to run the country? Or even less than that, is it really prepared to start trying to convince us that it can, out of its judicial hat, do all the kind of defining and interpretation necessary to run complex regulations? I don't think so. Next slide, please. And of course, we finally have the politics. Obviously, this attack on regulation, and to some degree, regardless of whether it's coming through ad law or First Amendment or equal protection, is coming from a place, from well-funded impact litigation that is happening at a scary rate around the country, using forum tricks, judges, and so on. There is really a nice summary of this in the Loper Bright amicus brief that Erwin Chemerinsky wrote for Senators Whitehouse et al., and that might be something you can look at and point students to. Next slide, please. So finally, what do I tell my students? I remind them again that we live in a complicated world, complicated modern society. unregulated laws are not delivering the social goods we all need. We need government to help produce the conditions in which we can be healthy. There's good evidence that policies that are humane and pro-human work. I point to the work of Jennifer Caras-Montez. Here's the one cited here, but there are others. We do not want people, I certainly don't teach people that regulation is always wonderful and everything the government does is good. A lot of what we do as public health lawyers is criticize government and sue government when it's doing the wrong thing. And that's important too. But complex modern societies need robust and effective regulation. Now, the court may not be going that way right at the moment, as the court has often gone the wrong way. But that just means there's more work for us to do and more call for legal creativity and constructive law. So let me turn it over to Marice for her reaction, which I've already seen.
So, folks, we debated amongst ourselves. Do we use language like "what the hell"? And we figured yes, we do, because there's other language that we thought of using that we thought wasn't appropriate for a webinar. We thought of dumbing it down, but we left with "what the hell." So again, we're at the public health is at the tip of the spear of what the Supreme Court is up to. You think of guns, reproductive rights, LGBT rights, the most traditional public health on vaccination and infectious disease control. Every single issue is at the tip of the spear, and we're kind of leading the way for the nation, for better or worse. So next slide. So I've done some brainstorming, and this is in the spirit of brainstorming. And again, I encourage people to populate the chat with strategies that you're using in your classrooms, in your workplaces, in your consultation with government or other organizations. So coursework, administrative law should be mandatory. Probably in some law schools it is. I think it needs to be mandatory in every law school. It's not in Berkeley law, but it's really necessary for anybody doing health law. Encourage students to take legislation or legislative drafting. I'll say more about that in the practice skills. Advocacy. The schools of public health are beginning to lean into teaching public health advocacy, and this would be a great way to have students cross-populate. Law students go to public health schools, and public health schools come take public health law at the law schools if that's available to them. I would add into this that I was just thinking as we were talking is epidemiology, and it would be really helpful to have epi courses available to law students. Some way of bringing law students, even if it's a short course, into understanding epidemiology, because it's always been important, obviously, but more important as we have to frame arguments so carefully. And I would also just encourage students to do their externships with government agencies. How does it work from the inside? What's going on? Having that behind the scenes look at how government actually functions, because that sensitivity will be absolutely essential to their skill set moving forward. And ditto for public health students. Most public health students, at least coming out of Berkeley, are going into biotech and hospital administration. In fact, my students are told they're being trained to be hospital administrators, not public health advocates. They're upset about that. And so again, getting on the ground experience with government agencies and encouraging employment and job opportunities and career development within the government sector is absolutely essential to all of us. So legal and practice skills, drafting legislation, clearly state current and future agency authority. So one of the things we learned from Loper is if the agency is given explicit authority, they can have it and they can exercise it. So be clear about that. Likewise, if they are given explicit exemption from judicial review, they'll protect the regulations. Check for use of racial categories. So if we can't go after, I just saw a case coming out of Louisiana that the EPA can't work on environmental justice from a race-based perspective, from racial discrimination because of the Students for Fair Admissions case. What are we going to do? We have to check if we want to be addressing racial injustice. How are we going to do that? And I saw some questions about that in the Q&A, so I tee that up for Scott and Micah to start thinking about. Is economic justice issues the equivalent or not, and what the hell, what do we do? Check for religious liberties. We know from Tandon now, and you can look at Fulton too, that if there's any way that our regulations could affect free exercise of religion, we have to account for that. And that's a call for epidemiologists and lawyers to work as teams with each other to understand how this will be implemented and to make sure we've got data on religious liberties so that we can account for them in a new way that we haven't had to in the past, or dismiss them as not being relevant for whatever reason. Another strategy is reading the dissents for roadmaps to the future. I think Kagan, Sotomayor, Jackson, occasionally one or two others, are giving us roadmaps and insight into where the court itself has some fissures and how those can be exploited. Employing impact litigation to limit damage and to expand protections. I have to say the anti-choice, the anti-abortion movement was pretty brilliant in chipping away, being willing to lose a lot of cases to find some fissures in different courts at different times. Where could they get an inroad and expand that slowly and deliberately over time? We have to have the exact same strategies. Writing amicus briefs to make the public health arguments. This has been done brilliantly. I'll call out Sarah Rosenbaum in particular, but the George Project and Public Health Law Watch too, taking on some of these cases to make sure that the public health arguments are expressed through an amicus brief. And then finally, and not the least, this maybe is the most important, is engaging in political advocacy and movement building. Lawyers learn how to be litigating advocates, but they don't really understand engaging with political movements. They don't get trained in that in law school. And I just harken back to our first slides on the 5 essential public health law services that this book is based on and the rest, that really it's that public engagement, bringing up local voices and giving power to outside of just the lawyers, even though we're talking about litigation and law, is absolutely essential to public health. Keep asking questions. My experience working with advocates over the years, I can harken back to the early days in tobacco control. It was the advocates that would say, well, why can't we do that? And how about this? We don't like the status quo. We won't settle for it. Why can't all housing be smoke-free? Why do we have to allow it? It was coming straight out of the advocacy movement, not us brilliant lawyers, not the scientists. It was the advocates on the ground that gave the voice to what drove the agenda over time. We've got to build our communications muscles. It's another webinar. Obviously play the long game and ultimately help originalism collapse under its own weight. The Bruin-Rahimi example is just one, but we've got to bring the right cases and bring the right data so it collapses under its own weight. So I'm hoping that you have been populating the chat box with your ideas, with any more questions. I'm going to, Bethany, you can promote the slide, and let's go straight to some of these questions. Some early questions were right about, well, I'm looking what we have here. There's a lot of questions about Dobbs. A lot of questions. Do we teach Dobbs? How do we teach Dobbs? I mean, we always had the Griswold, Eisenstadt, Roe, Casey, and now Dobbs. What do we make of this? And what do we do about it? And I'll just take Dobbs and kind of make that as a case study in the court taking away liberties, reworking. I mean, we've done it. They're doing it in guns even more than ever, and religious liberties, this wholesale. What do we do with the history now that we have this new, and how do we teach it? And Scott and Micah, I'm going to pass this to you to just give us some comments on that. There's a lot of that in the discussion, and where's your thinking on this?
Sure. So, I mean, I can just kick it off for a minute. So, I mean, I think Michael's question was a really good one. So, you know, it's important to teach how the law is changing, but there's also concerns about, you know, when there are disingenuous arguments about history, in the text of the cases? Do you actually assign the text of the cases? And I mean, my view is that for law students, yes, it is important to actually read the case and work through it and grapple with what the Supreme Court said, but it's also important to provide that context. So there was an amicus brief that was written by historians that challenges a lot of the factual assertions that the Supreme Court ended up putting into the decision. And so I also discuss that amicus brief and, at least provide some quotations. I don't make them read the whole thing, but provide some quotations from that to talk about the view of historians about some of these issues. There was some discussion in the text about, I think it was also from Micheal actually, about using JAMA viewpoints when instead of assigning people entire cases. I mean, you can't assign people all of these cases. So using things like JAMA viewpoints, if or the perspectives in the New England Journal, if they give a good summary. I've used that particularly when teaching public health students to give them an overview of the case and its public health implications as opposed to reading through the entire case. This is on my very long to-do list of things that I'm not going to get to anytime soon, is I think it would be helpful for someone from a public health perspective to go through Dobbs and do an edited version of the case that is more readable length for students. So if anyone wants to share that, that would be terrific. I have not gotten to that one yet.
I've done that, Micah, so I'll
Oh,
share
great.
it
Perfect.
at some point. Yeah.
Another thing that I like to do is, besides excerpts, is to give students a parallel view of a case in which it looks to me like they're actually trying to take the law seriously and not applying an outcome determinative approach, versus one where you're just sort of seeing a lot of attitudinizing to rationalize an end that the court wants to get through. And there's always examples. Oftentimes you can find those in the lower courts in the cases that get up to the Supreme Court, but it's interesting. One good example of that was the two vaccine cases from the previous term, from COVID, where we had SAMHSA's requirement for healthcare worker vaccination versus OSHA's requirement. And it was as if two different courts had looked at two different epidemics in two different times. They were so different. And that way you're not doing that thing where you're kind of valorizing or appearing to endorse or accept really bad lawyer behavior in which you're letting the students think hard about what the craft of law is when you take it seriously.
We have another question, and I'm heavily simplifying this, but it kind of goes to the core of public health and the core of what I'll call, these are my words, not the writer's words, the common good, which is when do we need social control and when don't we need social control? Public health requires some control over individual liberties, and with this new jurisprudence that's coming out, how do we find that line? And what's the role of us as pedagogical leaders in trying to determine that?
Well, I teach my students that there was really a lot of bad legal work and bad thinking about the law, poor planning, poor design in COVID. That this was not just crazy libertarians or the public good. And as I say, I've written about that. I'm happy to share some of those papers. We have a bunch of things going on. One is regulation is hard, and not all regulations work. Not all regulations are good. Objections to regulations can be reasonable. That's the first thing. Second of all, part of what we're trying to fight in our approach to teaching law as a transdisciplinary activity and to engage people who make the law, people who are not lawyers, the people who design and enforce the policies, competent to do that work, is that oftentimes there's a false belief that law is easy. And if you just make a rule, well, it'll get done. There are lots of ways to influence behavior. Law is one of them. What we ideally want our students to understand is how to recognize the many different ways that we can change behavior and then think in context about which one is best for the particular problem they're trying to solve. That is very different from a view that says, all we need to do is make more rules. The more rules, the healthier. I just think that's not true empirically, and it's a really dangerous way of thinking if you're working in public health in this day and age. You got to use rules carefully when they are the right thing to use.
Micah, rather than commenting on that, I want to get to two more questions if we can before the end, and I'll put them both out. One is, can we take this, what the hell, what do we do about racial discrimination issues, environmental justice, and all the other isms that go with that, given the Students for Fair Housing? And the other, well, let me just leave it at that. We're too short on time. So I throw that. Micah, why don't you start? Scott, your comment.
Yeah, I mean, we've got 3 minutes left, so it's a lot to cover. I mean, I was just kind of reflecting that I'm kind of shocked we're 57 minutes into an hour-long public health law discussion, and we haven't talked about Jacobson. And you know, I just want to sort of highlight Scott's work discussing this and kind of building on the previous question too. I mean, you know, public health has not always done things well, and I think we're pretty clear about that in our book and our discussion of these things. But I mean, the question is, you know, are we committed to a, you know, democratic process in which we as communities try to work together to tackle these problems, or are the courts going to you know, move towards a constitutional vision in which that is just kind of literally impossible, and the only thing that matters is individual liberty regardless of the health consequences of it? I think Scott has written really beautifully, if it's not one or the other, it has to be both, protecting both public health and individual liberties. And you know, there needs to be you know, an understanding that there are problems that can't be solved by just people trying to do them themselves. Those, you know, that is what the field of public health is all about. And so kind of coming back to that theme and think about how we're going to address those types of problems, you know, as civic communities, I think is what this whole venture is all about.
Scott, you want to give us a
Well, as I recall, we end the book with a quote from faith health leader Gary Gunderson, Pastor Gary Gunderson, who reminds us that people go into public health because they have a burning love for people and the public. They don't do it for the money, and they don't do it for the glory. They do it to do good. We got to remember that love, instill that love, but of course remind our students that it ain't blind. You got to see what's going on there. You got to be careful that you are being as clear-headed, as evidence-driven as you can be, consistent with, you know, while you keep that passion going. And that ultimately public health succeeds when it offers good solutions to problems that people care about. We can do that. We can do that better than anybody.
I'm going to call time because we're at the hour. I want to thank everybody. We barely scratched the surface, and I apologize for that. There's a lot here. Give us an email if more of this and maybe just some open discussion would be helpful to you as you teach. I know we didn't get to the epidemiology and the religious epidemiology questions. There's a lot in there that we haven't touched, but I think we're all willing and able to engage more with the field. So I thank you for joining us. I want to respect everyone's time, and thank you.